Good morning.
Good morning.
Good morning.
Excuse me. So do you guys have a court reporter? I see Meredith, the court reporter. Hi there.
Good morning.
Okay, just wanted to make sure, since my court reporter is very busy with criminal transcripts. So, okay, we are here today, Madam Court Reporter, on the case of David Bible versus the City of Roswell, case number 2017 CV 294723. I will note for the record that this matter is occurring by Zoom. My understanding is that we are here today on primarily a motion to dismiss the plaintiff's second amended complaint, although secondarily there is also a motion for judgment on the pleadings as to plaintiff's first amendment to the complaint. I've read all of the briefing. Although I feel like there are probably some issues that we're going to need to get our hands into specifically. And I'm just going to lay out there that as I understand it, and then I'm going to throw it open to Mr. Lael on behalf of the city, since it's the city's motion. And I'm focusing most of our attention here on the motion to dismiss the second amended complaint, because I think it's the biggest one that has the largest implications for the case writ large. And we need to figure that one out. So as I understand it, the city has moved to dismiss the second second amendment to the complaint. The amendment to the complaint alleges a cause of action, I think as it's characterized by the class, based on the GMEBS contract with the City of Roswell that has been adopted by the City of Roswell through city ordinance into the city's governance structure. And the city, I think I understand that the city's position is this throws, I've already ruled on, the court has already ruled on this on summary judgment, because it's essentially a different way to try to get at the same benefit, which is that defined benefit plan, which the court ruled on granting partial summary judgment motion was barred by the statute of limitations. If the GMEBS plan contract is a separate contract on which the plaintiffs could proceed, there would arguably, although I don't necessarily think there's a whole lot of argument anymore on that point, would be a 20-year statute of limitations that would apply, that would potentially throw open the floodgates, figuratively speaking, of potential class members, although I understand in more recent review, it may actually be a very small number of people or none at all, other than those that are already included in the class. That's what I think I know about this case. And so to the extent that I didn't say anything that was important that you want to bring to my attention, or that I've said anything that was incorrect, please take it away, Mr. Lael.
Thank you, Your Honor. We appreciate that you set aside some time for this matter, for this case. And thank you also for including the First Amendment, which I'll address later. But as to the Second Amendment issue, I think there are essentially two halves to what's before the court. First, if the court summary judgment order encompasses the theory raised in the Second Amendment, then that theory is precluded. So that's the first half. The second half is, if the theory is viable, and if the statute of limitations to the Second Amendment theory is nevertheless 6 years and not 20, it's barred under the same principle relied on in the summary judgment order. The city, as may not be surprising, contends it wins on both halves. But importantly, if the court determines that we only win on one half or the other, that still means that the motion to dismiss the Second Amendment should be granted. So I'm going to move now to a discussion of the first half of that issue, the summary judgment process. So this, as the court kind of alluded to before, this boils down to the scope of the court's summary judgment order. Plaintiffs contend that the amendment is permissible because it rests on allegedly new facts that were not ruled on in the summary judgment order. The city contends that the amendment is a recast theory of recovery that was already dismissed on summary judgment. To resolve these different positions, it's important to remember that the court granted summary judgment on statute of limitations grounds. The city put the statute of limitations directly at issue, and plaintiffs even agreed the 6-year statute of limitations applies. Thus, plaintiffs were obligated to meet the city's argument head on with any theories or arguments to rebut the statute of limitations, including the 20-year periods now being asserted. Their failure to do so precludes the Second Amendment, and moreover, the city's motion as to the defined benefit plan relied not just on the policy manual, but on plan documents showing the closure of the plan in March 2011. And in response, plaintiffs specifically addressed the GMEB's plan by name. Thus, they clearly knew what the argument was based on. The Georgia Supreme Court's decision in Summer Mentor declares that plaintiffs' efforts to revive a claim already dismissed on summary judgment is not allowed. They have what the court called, quote, a statutory burden in resisting defendants' motion for summary judgment to produce whatever viable theory of recovery they might have, close quote. Plaintiffs argue that the word ascertainable in Summer Mentor should be given a limited meaning and does not refer to whether the party knew or should have known about the cause of action, but only whether the cause of action was implicated by the facts pled in the complaint. But
Well,
nothing.
Mr. Lael, forgive me for interrupting you, but I definitely do not want to get down into the weeds of what the word ascertainable means in this context, for sure. But as I understand it, the way I think that the plaintiffs try to get around this argument that this is entirely foreclosed on summary judgment is by arguing that essentially this isn't just a different theory of recovery of the defined benefit plan benefits, right? That this is in fact an entirely independent contract. And so one place I do think it would be helpful for me to get down into the weeds a little bit, or have y'all do it for me because I need a little clarity, is that both parties have drawn my attention to the actual GMEBS contract. And I've looked through it, and the plaintiffs aren't wrong that it is. Clearly it's a contract to the benefit of the city. Clearly it's a contract between the city and the municipal employee retirement, whatever system that thing is called. And to the extent the plaintiffs urge that their clients would be third-party beneficiaries, they're probably not wrong. But where I do get a little confused is, why does the policy manual even exist if words like eligible employee and what that will be on for example, page 9250 of the most recent version? I know that the plaintiffs have drawn my attention to the older version, which I'm just going to point out is older than me. And I'm not even that young, and that plan is older than me. But the city has pointed me to a more recent iteration, probably just the most recent one that was adopted by the city. I think it was 2019 perhaps, but I can't swear to that, the one that the city sent to me. But on page 9250 of that document, it has a whole listing of eligibility conditions, which are, what is an eligible regular employee? It says the city has elected to say that will be 40 hours. I understand that perhaps my recollection of reviewing the policy manual is that it is slightly more granular in terms of defining those terms. But I think where I'm confused, part of what the plaintiff argues is, how do these two things coexist? How were they intended to coexist? Were they intended to coexist? And does the fact that they coexist support or detract from the plaintiff's argument that these are two completely separate things?
Well, I'll address that first. The policy manual, again, we have to be careful about time here. The 2002 policy manual actually has some summary documents of the retirement plan attached to it, and part of what was provided to the court as part of the 2002 policy manual kind of assemblage, which has several appendices, drug testing plans, various other things. So the idea there is that the policy manual lays out in general what the entitlements are, who's eligible, what the benefits are. That's in the policy manual, but the plan contains the nitty-gritty, and the plan documents contain the nitty-gritty. In the 2002 version, that's actually part of the overall package of the 2002 policy manual. For the 2014 manual, it's not appended to it, but it is referred to within, I think, section 9.7. It says, we you're entitled to the benefits according to the terms in the pension plan documents themselves. So they are intended to be together. And I would say again that having moved for summary judgment on the issue, we moved for summary judgment on the claim. And again, it wasn't just the policy manual we relied on, but we also relied on the ordinance documents that created an amendment that said, we're closing the plan, no more entrance into the plan. So the ordinance was put front and center. If the plaintiffs had a theory that an older ordinance or some other ordinance had some sort of bearing, it was incumbent on them to respond to that motion for summary judgment by raising that issue then, and not by holding it back. As one of the Supreme Court cases said, it's not permissible for a party to rely on some of its legs in arguing, and then once it's lost, to rely on other legs. And I think that's what's happened here.
Okay, thank you, Mr. Lael. Please go. You can continue. I just wanted to, I wanted to address that issue because municipal government is not my strong suit. I feel like I have a walking around knowledge of benefits litigation law and how that policy manual would work. But I think understanding how the benefits manual or the policy manual that has been, that the court has ruled, right, could be considered a contract in the context of these additional benefits. How that relates to the actual contract. And I think I understand the city's position, as you've just stated it, is that it's one thing, it's one entitlement to one benefit. It's just various iterations of explanations for and descriptions of that benefit and explanations for how you get that benefit, qualify for that benefit, how that benefit is administered by the city.
That's right.
Okay.
And I would also point out, going back to the original complaint and just touching briefly on this notion of ascertainability, that the original complaint in paragraph 30 alleged some details about the plan documents, including if you're hired before March of 2011, you get the defined benefit plan. If you're hired after that date, you get the defined contribution plan. So clearly, even within the original complaint itself, there was contemplation and ascertainability of the issues regarding who's entitled to these various things. So moving from that issue onto the second half, the statute of limitations issues, unless the court has more questions on that person.
You've answered my question. Thank you.
Okay. There are two theories that plaintiffs propose that would result in a 20-year statute of limitations for this proposed new theory. And the first is based on a 20-year statute under section 9322 of the Official Code of Georgia, based on a claim arising out of a statute. The Plymell decision, which we both addressed in our various briefing, is the only appellate case that analyzed whether a 20-year or a 6-year limitations period applies to a public pension plan. And there's no real difference between the statutory plan addressed in Plymell and the plan documents within an ordinance here. And the Court of Appeals determined that the 6-year statute of limitations applies, and it reached that determination even though the Teachers Retirement System statute spells out all the rights of participating members as reflected in our brief with respect to eligibility, service credit, contributions, vesting, all of that. And those same aspects are within the pension plan ordinance here. Nevertheless, the Plymell court concluded that the 20-year limitations period for statutory claims did not apply because the right to retirement pay, if it exists, arises from the contract of employment, not from the statute. And when it said that, it was looking back at previous Court of Appeals cases that deal with service. And if you put in your service, then you then have a contract or an expectation of getting a benefit that relies on the provision of service. And that's what we're talking about when we say contract of employment under Plymell. So plaintiffs have no answer to this, this reality because there is no answer other than the conclusion that Plymell controls the outcome and a 6-year period applies to this plan. As the state Supreme Court recognized in 1905, we put this in our brief, the purpose of the 20-year limitations period is for special cases not provided for by the general statute of limitations. Here, the plaintiffs assert a breach of contract theory, which has a 6-year statute of limitations under 9324. So there is a specific statute of limitations that applies to this kind of claim, and that's what it is. So that's the first 20-year theory that the plaintiffs have. The second one is based on documents under seal or instruments under seal, and that relies on OCGA 9323, which says that an instrument must contain both a recital in the body of the instrument to the effect that it's given under seal, and the signature of the party to the instrument must have attached thereto a seal or scroll. Georgia case law on sealed instruments is, to use a technical term, persnickety. Plaintiff's surreply takes issue with the city's analysis of the proximity of the seal to the signature of the maker, but that analysis tracks the case law's insistence on such proximity. Plaintiff's efforts to gloss over that insistence is not successful. In Eccles versus Phillips, going all the way back to 1901, because again, a lot of this case law is very old, the Georgia Supreme Court found that a promissory note was not made under seal. The signature of the maker was by itself at the bottom right of the document, and on the left side of the document were the words signed, sealed, and delivered in the presence of, with blanks for apparently for witnesses. Those lines were blank, so the court concluded the instrument was not under seal. The Eccles court.
Forgive me for interrupting, Mr. Lale, but I mean, getting granular about whether something is sealed or not was a necessary activity for a court in 1905 because seals mattered and notary stamps were physical things and they weren't just little stampy rubber things that we use now. Things were, the purpose of sealing the document was intended to give it the imprimatur of the court, of the significance of what it was. And I mean, does it do us any good to really get down into the weeds of was it under seal or not under seal if what your real argument is it doesn't really matter because they've waived any argument to bring this up because it was barred by this, because they didn't bring it when they were arguing for it as a basis for recovery of that defined benefit plan. I'm just not, are we really going to, am I really going to enter, I don't really want to get into the weeds of was it a half inch away or was it closer to this person's signature or was it closer to that person's signature?
Right.
So.
Well, to address those concerns, Your Honor, I think that the law is, as I said, persnickety. And if the seal is under one person's name, whereas, you know, here in some versions of the defined benefit ordinance, it's under the clerk's signature or it's under the city attorney's signature, but it's not under the maker's signature, the maker being in some years the mayor alone and in some years the mayor and all council members. So those proximity issues matter based on Georgia law. And with respect to the question about does any of this really matter at all based on our summary judgment argument, I think that gets into the two halves that I talked about before, that if we went on that half, none of this matters. But if you find that the summary judgment order didn't encompass this new theory, then these things do matter. And that might become part of the order granting our motion and denying the Second Amendment.
Here, so I think I understand part of the back and forth argument on this issue of whether it's under seal or not is that the original 1973 document seems to be fairly clearly sealed in some manner, although maybe we can argue about the niceties of it, but that its iterations going forward, it becomes slightly less and less clear as it moves forward. So if that is correct, and I'm understanding that argument or that assertion, what I didn't see in any of the documents, at least I didn't think so, is anything pointing to a requirement that it be under seal, right? Is there some requirement under statutory law or municipal law that the GMEBS plan or something like it is required to be under seal? Like, is it not effective if somebody didn't seal it properly?
No, Your Honor, that's not a concern. There is a requirement because of the statutory provision that one a current counsel can't bind a future counsel by entering into long-term sort of deals. Because of that rule, it did have to be an ordinance, but it didn't have to be under seal. So that's what so again, it wasn't required that it be under seal. It just had to be in ordinance form.
Okay, thank you.
Yeah, and Your Honor, I think you are correct that in the earliest versions, the 1973 version, the issue does boil down to a certain extent to the placement of seal around the signatures. But in the later documents, the recital language, which is one of the absolutes required under the statute, just isn't there, because it said approved and voted on, or approved and whatever by the mayor and council, instead of saying signed and sealed, or didn't have that sort of magic recital language to it. And so then the seal placement doesn't really matter. So the later and later you get, the less issue there is with finding that it's not a sealed document, because that recital language just isn't in the language of the agreement. So I guess with that, unless you want me to go through the details of each iteration of the defined benefit plan, which we did in our brief, I think that concludes the city's position on these statute of limitations issues, which constitute the second half of the issues in this motion. But again, I think in light of all of the things that we've brought together, this is an effort by plaintiffs to relitigate a dismissed claim based on documents available in discovery under limitations periods that don't apply, and they all should be rejected, and therefore the city's motion should be granted.
Okay, thank you, Mr. Lale. And who am I going to hear from for this? Okay, thank you, Ms. Jordan.
Hey, good morning. Thank you so
morning.
much. I think I'm going to hit head on first in terms of this whole idea that this was something that should have been litigated or has been litigated with respect to the summary judgment order. What the city is arguing basically turns the whole idea of summary judgment and how it works on its head. Summary judgment, that briefing specifically with respect to Mr. Lau, you have to look at what they moved on, right, with respect to their contract claims. And if you look at their theories of recovery, or if you look at their briefing, all they talk about specifically is the manual, right? The policy manual. They say this was not a contract, that the ordinances that adopted it very specifically said through the years that these policy manuals do not constitute a contract. It is still a factual issue in the case per what you have said, Your Honor, in terms of the pretrial order. Is the policy manual contract? Is it not? Which is really what they were litigating or what they were moving on in terms of the summary judgment. They were not moving on the underlying or this separate contract. And I say it's separate because it's completely separate. It has its own ordinance. It has its own language. It is a completely separate contract between the city and between the municipal folks. So it's one of those things where they're trying to conflate and say that really it's all the same things because, the policy manual talks about benefits. This is a type of the benefit. Ergo, when we moved with respect to the contract claim, we really meant the whole thing. And that's just not not true in terms of kind of the factual record.
I understand the plaintiff's argument, but I think what I'm struggling with is that if the original claim is I'm entitled to benefits under the defined benefit plan, right? And the city is contractually obligated to provide them to me, and they didn't, therefore I can sue them. That's in a nutshell, a sort of layman's understanding of what the original claim was. And then the court said, well, the policy manual doesn't allow you to recover those benefits because it's barred by the statute of limitations. And then now we go, wait, there's a different contract that entitles us to those benefits. Does that really change the nature of what's being requested? Because ultimately the theory of recovery is to get to the remedy. And the remedy here that the plaintiffs seek is entitlement or compensation for not being entitled
Right.
to those defined benefit plan.
You're exactly right. It is about the remedy. But as you know, there are different theories that can be asserted by plaintiffs, even within the same document, right? Quantum merit, breach of contract, that seek the same remedy, right? But at the end of the day, they can be different theories of recovery. And so just because there was this one contract claim that the court entered an order on, specifically with respect to the policy manual and specifically with respect to the statute of limitations. And I want to be clear here, that is why their plaintiffs agreed that the 6-year statute of limitations applied in that context, because it did with respect to the policy manual, right? We understood that. And so that is that is kind of the vehicle to get to that remedy at the time that the court actually ruled on. And look, and so maybe you're thinking, well, but this is a whole different statute of limitations. Doesn't that make it different too? Like this doesn't, because at least with quantum merit and contract claims, maybe they're the same SOL. Well, think about it from the context of defamation and intentional infliction of emotional distress. Defamation is a 1-year statute of limitations. Intentional infliction is a 2-year, right? It can be the same operative facts. It's the same remedy. That's what you're getting to. It doesn't, if a court threw out the defamation claim based on statute of limitations, it does not mean that someone can't come in and then try to bring it under the intentional infliction. And that's exactly what this is here. We're talking about the remedy. We're not talking about the claim. And that's kind of
but I understand. No, that's fine. I think I understand the city's response to that, though, to be, you're absolutely right, except that the court's already granted summary judgment on this issue. And that essentially I think it's sort of a shortcut res judicata or claim preclusion argument, right? That just as if this case had been fully litigated through a trial and reached a verdict, you couldn't turn around and come back and say, oh, now we have this contract to litigate, because the courts would clearly say that type of claim is precluded because you had an interest between the same parties in litigating those claims. And I think if you take the city's argument to its logical conclusion, right, that if a grant of summary judgment is, according to the Court of Appeals and various, appellate courts, functionally the same as it's an adjudication on the merits. It's functionally the same as a trial, albeit, as a matter of law, based on undisputed facts. Then how is this second bite at the apple not precluded under that theory? And that's really what I'm struggling with, because everything you're saying makes complete sense, except the part where the intervening ruling on summary judgment as to that issue.
Look, y'all should look at the Giordano case that we've cited specifically. It's one of those things where, as a matter of right, we can amend prior to the entry of the pretrial order, right? Okay, so let's set that aside. With respect to what has actually been litigated and heard by the court, it is specifically on a certain contract. There's no question about that if you actually go back and look at what the papers say, what the pleadings, even what the court ruled on. And then we can even go back further and look at the class certification. The class certification itself was based on the policy manual. And that was recognized even by the Court of Appeals at the time, now Justice McMillan writing for the court. The contract was the policy manual. And so just because there is a different contract, you can't say, well, now because you litigated one contract claim that was a way to get you to the same remedy or to the same damages, then you're precluded from going forward. Now, I think you're correct that if we waited all the way, through judgment, yeah, we would be in some hot water to some extent, which is exactly why we had to bring the claim, because then we would have been actually hurting the absent class members. And this is what you have to do as class counsel. You have to make sure that you're protecting everybody who's here and who isn't. And this is a claim, a separate claim to get to the same benefits. The court said that the other road, the route to those benefits, was precluded because of the statute of limitations. We have now brought this second contract and say, look, this has a different statute of limitations. It gets us to the same benefits or remedy, but at the end of the day, it is a completely separate contract. It is a completely separate theory. It's not even a straight contract claim. It is a third-party beneficiary breach of contract claim, and which in and of itself has its own particularities, its own kind of evidentiary burdens. That has not been litigated at all. And so to say that it's the same thing, and then, so of course we've waived it. I think that is, I just don't think that, I think that's error, to be quite frank. You have a whole different contract, you have a whole new theory. The remedy may be the same ultimately in terms of the benefits, but to say that this claim has been adjudicated by this court, that it's been ruled on with respect to the summary judgment order that's been entered, I don't think that's the case. And I think it's belied by the actual order and also by all of the pleadings and everything that's been filed in this case previously.
Okay. Moving forward to this issue of the statute of limitations, right? So I think I understand the city's argument to be, even if the court says, okay, well, I didn't already adjudicate this on the merits, this is a different contract and I have to deal with it, that the plaintiff's theory that it's either an action based on a statute or it's an action based on a sealed instrument under those two statutory structures. I think I understand the city's position to be that Plymel, I'm not sure how to pronounce that name, would still preclude it because it doesn't change what the intention was of a 6-year statute of limitations, because it's still a contract. Talk to me a little bit about the plaintiff's response to that issue.
It absolutely is different. Can I get access? Because I've got some slides that I can.
Yeah, you should have free access. I don't limit your ability to screen share.
Okay, well, let me see if I can do this, and then I'll pull up some stuff and we can just walk through the law. Because it is, while it is law that has been around for a really long time, it is something that hasn't necessarily been litigated a lot. So, I think it is important for us, to really be careful and look at it closely. Okay. So with respect to this, there are two different grounds with respect to the statute of limitations 20 years thing. First, moving under OCGA 9322, which is enforcement of rights under statutes, right? And so this is something that says, if a contract kind of comes out of law or rights are established by law, by just generally, then that statute is entitled to, that contract is then entitled to a 20-year statute of limitations. Now, the flip side of that is that if it's a wage claim or an overtime claim, then it actually pulls back on the statute of limitations and says that it has to be brought within 2 years. So it kind of gives, but it also kind of takes back as well. And this has been applied specifically in the context of ordinances, for example, where there were wage issues specifically, and the Supreme Court, applied this and said, look, this statute applies when you have a city ordinance. And specifically, all of this is cited in the briefing because there aren't many cases specifically on this. But it says because this benefit, this wage, this ability to get to this remedy comes specifically from a city ordinance, then 9322 applies, and not the normal statute of limitations that you would have, which I think both parties below had said it was 6 years. But it was the Supreme Court who said, no, that's actually wrong, because this contract actually came about as an operation of law. So what statute should we be looking at? Well, first off, you have kind of the big statute, which deals with the Municipal Employees Benefit Statutory Scheme. And if you look at 47-540, it specifically talks about that each employer is empowered to establish a plan. But in order to do that, the employer has to enact an ordinance or resolution. All right, that's A1 right there. So you're like, well, who's the employer? Well, in the definition section 47.5.2, it said employer means the municipal corporation of this state. All right, so here we've got a statute saying, look, cities, you can do this. You can establish this if you want, but you have to do it by basically passing enabling legislation, right? It has to be an ordinance. And so that's what we have here. So this is the 2000 iteration of the plan, right? And so if you look at it, we have page 1, which starts the ordinance, and then you've got basically all of kind of the very granular things with respect to the plan that make up the body of the plan that are sandwiched in between the two parts of this ordinance. And so you go to page 60 and it's like, this continues the ordinance from page 1. And so I think the reason I wanted to show this is because I just think that it shows that really the plan and all of this together is basically it's one thing, right? And it actually kind of follows what the statute says you need to do in order to establish one of these retirement plans if you're a city. And that's exactly what the city did, and they started in 73. So with respect to Plymouth, and while it's different, what's interesting is that if you look at, so one of the things I did is I searched through the teachers' retirement benefit system statutory structure. I looked for
that was fun.
Any word ordinance, any word resolution, any word in terms of governing body, right? Because what would you think? You would think, well, a local school board would maybe be the governing body. Would they pass an ordinance? Would they pass some kind of resolution? There is absolutely nothing with respect to that. That statute in and of itself, it stands alone and is very different than the situation before us, where we actually have a city passing an ordinance, which then establishes this right to a benefit, which is exactly the situation that we see in the other cases handling claims under 9.322, even though they applied the 2-year statute, right? It's still the same application. What's interesting is that the one case that does apply the 20-year dealt with a firefighter who was trying to get pension benefits. And in that case, the court said that the 20-year statute of limitations applied. That's about as close to you get as on all fours, right? With respect to a particular case. But it is important to show that the case law that has come before has said that an ordinance satisfies the under law language, right? And we have that here from the very beginning, from 1973 all the way up to the present. And so I think that is very important with respect to the under law argument. Questions, or I can go on to the seal.
Yeah, 2 questions. So one is, am I understanding correctly that the way that that from the plaintiff's perspective, the way that you are distinguishing the Plymell case is that involved the state statutory teachers retirement structure as opposed to a municipal structure that's adopted into city municipal code. Is that correct?
That's one, but the secondary thing is that really it's the individual teachers' contracts, right? That controlled really at the end of the day. Now there were some broader things within the statutory structure that say, well, it should, you should do certain things, but with respect to every individual teacher, that was the contract at issue. It was the employment contract. Specifically here, what we're saying is that the contract, because it's this third-party beneficiary contract too, is this plan that was passed by the city of Roswell, and basically is part of this ordinance. And the only way that the municipal corporations can even establish this or get access to it is to comply with the statute at the state level that says you must pass an ordinance in order to do this.
Okay, thank you.
In terms of what's interesting, the seal and the under law argument, there's a lot of things that are the same, because we can talk about some of the minutia with respect to the plan. And so what we see is we've got the sealed instrument statute, which is right after 22, right? And so it's important to look at the instrument or the contract that we're talking about. And so what I've done is for 73, 87, and 2000, I've laid out very specifically what they say. And honestly, there's been some tweaks through the years in terms of amendments, but really the core of the plan has not changed. And so, you know, after 2000, I think it was in 2003, they adopted, it looks like more of kind of a master plan where you can just click the boxes.
That's what I was going to say. The more
Yeah.
recent one, it seems like one reason maybe it hasn't changed a lot is because there's a template and a sort of closed universe of what the
That's absolutely
GMEDS
right.
wants you to do.
That's absolutely right. And I think with respect to this, it was almost made easier with the click the box thing in terms of if you wanted to do any changes. And so what's interesting is that even in the 2003 language, you can choose whether or not you want to adopt a whole new plan, right? Or if you're just making some amendments. And I do think that's important in terms of the seal argument too, because to be quite frank, I think we start with the 1973 document that is clearly under seal. I think everybody says that. And then really see that through the years, 87 and 2000 and even 2003, which really would be the last controlling document, because I think the next one was 11, which then, you know, at that point, we don't have a defined benefit anymore. And
Isn't that why the 11 plan was adopted, was to specifically exclude and note that future employers after March of 2011 would no longer have access to the
That's it. So that's kind of when it closes off, right? So, and at that point too, the language consistent through all three of these iterations that I have before you say that, look, once you have a right under one of these documents, it doesn't matter if an amendment says it's gone. Once you have it under one of these documents, it doesn't go away. You can't amend to take away somebody's rights. And that's in all three of the documents. So what we see here is, so what's the instrument if we're talking about in terms of the sealed analysis or even under law? Well, the contract really is the ordinance, right? The plan that's sandwiched in between, and then the joint trust agreement. All three times, right? That's what we see with respect to this, anytime any changes were made. Then you see the ordinance, right? And really the only changes with respect to the language here, 1973 still did it old style by calling it Georgia laws, 1965, all that. By 87, we're referring to OCGA, section 4751. But with respect to this, the ordinance, this language is all the same and says, look, this is a contract for the benefit of the employees of the city of Roswell. And this contract is made up of the ordinance, the plan, and the joint trust agreement, all three, right? So then we go to Article 1, the purpose, same thing. This constitutes the retirement plan for the exclusive benefit of city employees, 73, 87, 2000. Again, 73, 87, 2000. And look, it says section 3 there and section 8 here. The only reason there's a difference in terms of the section numbers is because between 73 and 87, they changed it to alpha order, right? ABC order. But the language is completely the same. What is the contract? It's the entire contents of the ordinance, the plan, the joint trust agreements, and any amendments made thereafter, right? So what we have is 73, and then 87 and 2000 are effectively amendments. And there were tweaks in there, but in between, but these are really kind of the meaty ones. And then the plan. Again, we say the same thing over and over again. And it's the same language. It doesn't matter. Now, I think this is important because it talks about the eligible employee shall mean any full-time employee, right? But who's a full-time employee? Well, in 73, in 87, in 2000, a full-time employee was somebody who worked 30 hours a week, right? We're not even talking about 40 hours. We're talking about 30 hours a week. That's what established there. That changed in the 2003 iteration. That was the amendment. They bumped it up to 40 hours a week, but they never carved out specifically that firefighters shouldn't be entitled to it. And in fact, there's language in the 2000 version, even in that little, just kick the box, that you could actually say, well, here's a class of employees we are not offering this to. They had the ability to do that. They had the ability from the beginning, throughout this whole process, and into 2003, which really was the last time there were any substantive changes made to the plan. But again, all the same. It's absolutely the same throughout. Again, so then you go to, all right, well, what are the eligibility and qualifications? I mean, well, maybe that's where they're going to say that, you can't do it if you're a firefighter. No, absolutely not. Again, we see the 30 hours language. We say in any person who, if you're employed for more than 6 months, that it's the same kind of going across the board. There are some tweaks, but has nothing to do necessarily with the core of the plan and in terms of who the beneficiaries of this plan are for and who actually should be able to take advantage of them. Contributions are the same. I think what's important to this is that 73, 87, 2000 participant contributions, the participants shall not be required to make any contributions all the way through. So while there is this issue, I know, or this question in terms of the defined contribution plan, where it's like, well, who would have really taken advantage of this? I know that is an argument that they've brought up before. Like, really, is anybody really going to contribute to this in the first place? With the defined contribution plan, that's not at issue because the participant does not have to contribute with respect to money. That is why this is such an important benefit to employees. And then, of course, when we're talking about is something sealed, isn't, and I know, and I agree with Mr. Lowe to some extent that this stuff is important, but you have to remember that a lot of the cases that are cited, we're talking about two parties that are entering into a contract, right? And it isn't, so the fact that maybe the seal is by the city attorney versus the clerk or whatever, that doesn't matter from my perspective because the city attorney is the city, right? Like, the city attorney isn't some independent person entering into this contract. The only reason the city attorney is even signing this is by virtue of the fact that he's an agent of the city. But apart from that, look, seal, the city has caused it seal. I mean, whether you're talking about the magic language, whether you're talking about the word seal, whether you're talking about an actual seal, it's all over these documents. And I think what's important too is that you start with the 73 document and it's like, well, I don't think there's any question there, right? It's got the magic language, it's got the seal, it's got all of that stuff. Well, quite frankly, the rest of everything else are really just amendments. The core of that document is absolutely the same. And even when you're talking about the amendments that came after with respect to 87 or 2000, if you read the ordinance language, it says we want to basically sub Article 1 through Article 10, let's say. It never says we are completely doing away with what we started with in 73, right, and starting over. So effectively, anything that even came after is an amendment and not, it doesn't take the place of the original core document that was actually under seal. And oh, by the way, there's indicia and evidence of them wanting to carry that through in the other documents. So I think that's important. And look, we're at a motion to dismiss stage 2, right? These are questions in terms of, okay, what do we think about this? Like, is this under seal? Is this not? And all of the case law really is at the summary judgment stage. So it's one of those things where I think it's important to remember kind of, what the standard is in terms of determining whether this should be dismissed or not.
I agree with you, but one question I do have, and it goes back to a question I asked earlier about whether or not sealing was required. And I think one of the things one of the reasons I'm asking that question is that if there's nothing that says that in order for this to be effective, it must be under seal, then why would it be improper for us to interpret the sealing as anything other than an artifact, a leftover, reminder of days gone by that isn't significant or dispositive of any legal issue in this case?
So I actually take the opposite from that, which is there is no legal requirement. And I looked high and low. I called everybody that I know who has ever represented a city, who has ever done any of this. I looked at bonds because bonds are supposed to be under seal, right? And I'm like, what does that look like? Well, you just put the word seal on it. Okay. This is not helpful, right? Called down to the Fulton County Superior Court. I guess there's a bond docket. I'm like, what is this supposed to look like? You don't have to have it under seal for it to be effective. So the fact that they did it means something, right? The fact that they did it means something. You can't just say that's an artifact, especially when you have a statute that says these instruments or instruments under seal are treated differently. They are given this 20-year statute of limitations. And I'll tell you the reason why is because look at the fact that we're talking about really a contract that started in 1973. And when we talk about pensions or kind of retirement plans, you have people that are coming into the system when they're 18 years old, right? Like they don't even get to the retirement benefits for how many years, right? And so that makes perfect sense to me that then a document like this that has this much significance and that will be operative, right, for years and years and years should be given that extra 20-year statute of limitations. And in fact, on the face of the documents, it's clear that there was an intent, a clear intent for it to be placed under seal. And it has to mean something. The court just can't say, well, maybe it was just some kind of template or whatever that nobody cared about. They just unintentional. You can't discard that in light of the plain statutory language that does treat these contracts differently when they're under seal.
Thank you.
Also, and this is, I think, more of a summary judgment thing, but with respect to what goes into, what did we say the contract was? It's the ordinance, it's the plan, it's the joint trust agreement. And so with respect to 9/3/23, it says, you have to have some of this language in there that indicates the intent for it to be under seal. Well, in all of the joint trust agreements, the signature pages, they all have the magic language. So the joint trust agreement is part of the whole contract. And you can't just say, well, that's one part of it, and we're just going to throw that out because it doesn't support our argument. It is part of the contract, and it's just evidence of the fact that there was an intent to have these placed under seal.
So going back to the sort of earlier discussion we were having about the nature of the remedy, the ultimate remedy being the same here, right? Which is access to the defined benefit plan or benefits under that plan. I asked Mr. Lael, I'm going to ask you, I don't understand how these two contracts in the context of this case, right? So if I'm accepting the plaintiff's argument, right, that the GMEBS contract between the municipal employees, whatever board, and the city is an independent contract of which the city's employees are third-party beneficiaries because the city elected to adopt that contract. And then separately also accept what the plaintiffs have urged since 2017, that the policy manual is a contract. How can those two things exist and not be in conflict with one another? I mean, what my brain keeps going to is in ERISA, right? You have the plan that nobody ever sees and nobody really actually knows what it is. And then you have the summary plan description. But the summary plan description, although everybody uses it as the way to understand the nature and scope of the benefits that are being brought, nobody necessarily asserts that it itself is the contract. It is merely the representation to employees and plan members of what the contract provides for. So is it wrong for me to think of the policy manual in that way? And if I do think of it in that way, why is it not all part and parcel of the same thing?
I think it is wrong for you to think of it that way. Look, in terms of the policy manual, the way that it was litigated, the way it was pled, it really was a contract between the city and the employee, right? That is what plaintiffs have asserted, that because of this contract between the city and the employee, we are entitled to certain benefits, not limited to, right, the defined benefit. It is any benefits that a full-time employee that is employed by the city of Roswell is entitled to, right? Whether we're talking about vacation time, holidays, sick days, whatever it is, that we're entitled to that by virtue of the fact that this policy manual says that full-time employees are entitled to benefits, right? Just kind of generally, it's a very general kind of thing.
Right, but to that point, here's where, if I don't think of it that way, if it's wrong for me to think of them as sort of conjoined things, right? Because to your point just now, right, that one is a contract between the city and its employees, and the other is a contract between the city and the municipal board, and that those two things are separate. Here's where, if they're separate and they're not in fact the same thing, then does that mean that the employees would be entitled to the defined benefit plan twice because there's two contractual rights to get it?
No.
And that's what I'm having a hard time reconciling.
No. And that's important. That's why, you will plead quantum merit and contract.
Alternative theories, right?
Right. By the time you get to trial, right?
You got to pick a horse.
You got to pick a horse before you can't get a double recovery. So there can be various theories. There can be various roads to get you where you want to be, right? And again, thinking about defamation or intentional infliction, it's the same remedy and the same remedy for the damage, but you got to pick a horse. You can't get a double recovery. It's just the way it is. And we absolutely know that. I mean, there wouldn't be a situation where you're like, well, the policy manual, we get the defined benefit. Oh, and now we got this defined benefit. And now we got double defined benefits. No, that is absolutely not what this is about. This is about that under the policy manual, you made a decision that it was the claims there were barred by the 6-year statute of limitations, right? You did not, on any kind of substantive ground, say there's not a contract, employees aren't entitled. It wasn't anything. It was very simply statute of limitations. That's it, right? As of 2011. Well, with respect to this contract, what we're saying is this entitles us to those benefits, and we don't have the statute of limitations issue, whether the court finds that it was under seal or whether the court were to find that it, because of the ordinance and because of the statutory structure of it, it gets that treatment because of 9-3-22. Whether you want to do 9-3-22 or 9-3-23, it's a 20-year statute of limitations. I mean, so it's one of those things where this is a rare thing to have happened, but it's not novel. I mean, the seal stuff has been around. I went back and I think we put it in our briefing. I mean, we went back and looked at the statutes from like the late 1800s. This has been around. and it hasn't been changed. So the whole idea that, well, this is just kind of an artifact of the past. Look, we haven't done away with it. I mean, and it's not like the legislature is not hot to trot about just about everything, passing as many laws as they can possibly pass. So if this were really a problem or something that didn't apply anymore, or just some kind of outdated concept, I think it would have been acted on by the General Assembly, and I can kind of speak to that with personal knowledge.
I was going to say pretty authoritatively on that point, Ms. Jordan.
No.
Thank you very much. Does that conclude your presentation? I was going to call on Mr. Lael for rebuttal.
Yeah, if there's anything else, I know they talked about in terms of not being able to be able to amend and all that. We're happy. I think it's all addressed in the briefing, but we're happy to address anything that the court is interested in or has questions on.
Okay. No, I appreciate that very much. Thank you. Mr. Lael, rebuttal for the city?
Sure. Just to go back through the order of the issues, I guess. Ms. Jordan assessed that the issues here are not novel, and I would agree. He also said that if the plaintiffs had waited until judgment was entered before raising this new theory, they'd be in trouble. And so I would posit this hypothetical. The case originally was only about defined benefit plan benefits, and the court entered summary judgment on statute of limitations grounds. The case is over. If they tried to amend at that point, I think it would be a much clearer case, but effectively that's just a different way to think about exactly what they're doing, which is that the court reached a decision, entered judgment in favor of the city, and did it on statute of limitations grounds. And so when I think it was Mr. Somerville that in the last hearing, the pretrial conference hearing, said, we just put our thinking caps on and we realized there's documents under seal and all this kind of stuff. Well, the thinking caps could have been donned earlier. So this was an issue that was presented. It was certainly squarely presented as a statute of limitations issue. So to the extent that there was another theory or another way to approach it, that should have been raised at that point in time. The bulk of Ms. Jordan's presentation went through various provisions of the different iterations of the defined benefit ordinance. And that structure that she described, look, here there's eligibility, look, there's this, that's exactly the way the teacher's retirement system statute is set up. And notwithstanding that structure, Plumell, the Court of Appeals in Plumell, determined that the 6-year statute applied. And again, it referred back to, it's on the left side of the page the way it's printed for me, but I think it's the Alverson case and one of maybe Parrish that get into the notion that as a public employee, if you provide service under a benefit plan that requires service, that becomes part of your contract of employment. And so Plumell said, that's what the contract is, and that's a 6-year contract term, not the statute itself, which only determines the calculation of the benefit. So I think that same thing applies here. So even though she went through the structure of the ordinance in detail, which is fine, that doesn't really get the plaintiffs to where they need to be, because the same thing could be said for the statute in the Plumell case. And I don't know that this is a huge point, but Ms. Jordan represented that the subsequent amendments are merely amendments to the 1973 ordinance. And that is true in some sense if somebody was employed and then terminated before the next amendment. But for anybody who continued to be in employment, the subsequent versions have language in them superseding the language of the previous version. So the way it would work is if you terminated, if you worked there between 73 and 87, but you terminated before the adoption in 87, you're governed by the 73 version. If you were still employed after 87, but you terminate before 2000, then you're governed by the 1987 version. I know this is kind of weird and arcane detail, but that's how that would work in terms of going through these various iterations of the ordinance. So again, I think Plymell speaks for itself. Unlike the case that Ms. Jordan cited that we addressed in our brief, where no alternative was provided, the Plymell case is the only one that weighs the 20-year statute versus the 6-year, and it concluded 6-year was applicable. And again, I think that's pretty straightforward. And I think on the seal arguments, again, the courts get into the nitty-gritty about where the seal is placed. And is the language there in some of the earlier versions? Absolutely. And we acknowledge that. But the seal was placed with the city attorney or the city clerk and not under the signatures of the makers. And I think that's significant here in a situation that would result in the extension by 14 years of the applicable statute of limitations. So again, we believe that the motion to dismiss should be granted. And again, we thank the court for its time. And unless you have other questions, I'm happy
I do
to
have
move to
one
the-
other question, Mr. Lael, and I think it is a broader question. I mean, it relates to the motion to dismiss, and the question is relative to the standard here, because I think plaintiffs are right to point out that, granted, we are 7 years into this case, right, or however many long years we are into this case, but since 2017. And so we're not usually focused necessarily on the standard for a motion to dismiss at this late stage. But the plaintiffs are right to point to it, right? I mean, I routinely deny motions to dismiss, like, all this is great. I appreciate you telling me all this stuff, but the standard for a motion to dismiss is so low that is really just not a point in having this conversation. Now, I agree that we're in a different position here, because to deny the motion to dismiss and allow this to go forward requires us to sort of go back and reinvent the wheel and go back and open the class and figure out what that certification process looks like. But I did want to give you an opportunity to address that particular point that the plaintiffs have raised, is all of this information, right? We are having a much more fulsome conversation than we typically would be having on a motion to dismiss, because we are so far into this case. So how do I reconcile the relief that you're requesting with the legal standard that applies, right? Which is, if they have alleged any facts from which, if proven, they could be entitled to relief, that I should deny the motion to dismiss?
Well, Your Honor, fortunately here, we're not really disputing what the facts are. I mean, the facts are in the documents. So a motion to dismiss is based on the law, not the facts. The facts are what they are. The documents show what they show. So it's really kind of, putting it in the court's lap of, all right, so apply the law to these facts. And we've each done that in our respective briefing to try to show how the law applies to these facts. And again, I think given the state of the law on summary judgment, the state of the law on these different 20-year theories, that the law is there to answer this question at the motion to dismiss stage. And, is it an aggravation that this last minute set of amendments was made when we've litigated this case for 6 years? Absolutely. But I think the immediate issue before the court is, all right, now that you've done it, what do I do with this First and Second Amendment? And again, I think as a matter of law, the court has in the briefing the legal analysis to help it reach the appropriate decision.
Okay. Thank you, Mr. Lael. So I think that answers, I think that sort of concludes the primary discussion on the motion to dismiss the Second Amendment. There is still the issue of the motion for judgment on the pleadings as to the First Amendment. Setting aside for a moment the plaintiff's argument that that wasn't reserved in the pretrial, and I say setting it aside only because I can look at the pretrial order. They're right. It's not there. But I remember discussing it in some detail during the pretrial conference itself, because what I keep coming back to is that issue in particular initially was raised as an evidentiary issue for a motion in limine in terms of the scope of what the expert would be able to testify about. And then it morphed into the First Amendment, where it really was an amendment of the complaint to include actual claims for wage damages, as opposed to using the wages to calculate the benefit under the defined contribution plan that the employees would have access to. And so the reason I'm still going to let you argue and make your record, plaintiffs, but the reason I say let's set aside that issue for a moment is that you're absolutely right. It's not in the pretrial order. And I have not gone back and read the transcript, such to the extent that I even have one of the pretrial conference, but I specifically remember discussing that issue. And so that's why I feel like it might be the court's error that it wasn't preserved. And I'll, again, let anybody preserve their record, but I just wanted to, in full disclosure, let the parties know that that issue is not really where I am. I do think we need to address that motion for judgment on the pleadings more substantively. And with that, because it is the city's motion, I'll let you go ahead, Mr. Lael.
Thanks, Your Honor. Just as a reminder of context, we moved for judgment on the pleadings with respect to the First Amendment based on essentially a simple proposition. There is no contractual basis for the alleged contract claim seeking a wage differential for the plaintiffs. The policy manual, the supposed contract for this claim, so we're not talking about some other contract, this is the policy manual purely, just doesn't provide a mechanism for determining the pay rate of a previously part-time employee becoming full-time. Moreover, the classification plans that are attached to or referred to in the policy manuals don't even list a full-time rate for a firefighter. So the plaintiffs cannot assert a contract claim because there's just not a contractual basis for it. So in response to that, our motion was pretty simple, like 4 pages. In response to that, plaintiffs make 3 arguments. And the first is what the court raised, that because a briefing schedule was not specifically agreed to in the pretrial order, the city's motion for judgment on the pleadings was waived. But waiver of an issue in a pretrial order requires omission of the issue, not a failure to set out a briefing schedule. And as the court pointed out, we did discuss it. And even in the last paragraph of section 7 of the pretrial order, the city stated its position that the hypothetical full-time differential is not even a viable claim. So that issue is certainly preserved, even if we didn't set out a briefing schedule like we did for the Second Amendment, which again had these class implications and warranted that more in-depth treatment. Second, the plaintiffs criticized the city for having filed motions in various contexts on the wage differential claim, and that we're taking another bite at the apple, so to speak, in filing this motion. But they also acknowledged that the First Amendment constituted their effort to, quote, make crystal clear and to, quote, remove all doubt about whether plaintiffs properly pled the wage differential claim. These are at their response at page 2 and page 6. So if anything, the city's motion for judgment on the pleadings simply maintains its previous objection to the wage differential in light of the context of an amendment to the complaint. Third, they point to language from the policy manuals that the city commits to fair pay based on salary surveys. However, each provision also refers to the director of HR making recommendations on the pay for a position. Thus, there is no contractual formula leading to a particular result. Again, not a particular contract provision they can rely on. And plaintiffs also argue that the failure to exercise discretion appropriately can constitute a violation of the duty of good faith and fair dealing. And for that proposition, they cite 3 cases, but they reflect more of a scheme of wrongdoing that just isn't present here, such as withholding consent to a property sale when the underlying contract says the consent will not be unreasonably withheld. That's the Hunting aircraft case. Or soliciting liens on property to force a sale. That's the West versus Kaufman case. And the failure to perform a specific act dictated in the contract itself, which is the City of Atlanta versus Hogan Construction Group. So all of those things show that the city's motion for judgment on the First Amendment should be granted, and that the plaintiff's efforts to block an argument or to refute the argument on the substance are just not successful. Thank you.
Thank you, Mr. Lael. Who am I going to hear from for the plaintiffs?
Chris Alderman, Your Honor.
Hey, Mr. Alderman, how are you?
Good, how are you?
I'm doing fine. Go ahead, sir.
I think it's important. We've spent a long time a little over an hour talking about the Second Amendment. It's important to keep in mind this First Amendment has absolutely nothing to do with the GM-EBS contract. This is all policy manual contract. I know that you're aware of that. We're about to get into the substance, and I don't want things to overlap. So our view on the First Amendment is there's really nothing new. We had an expert report. In that expert report, the expert calculated the wage differential damages. Their expert disagreed with that in his report. They filed a Daubert motion seeking to exclude that opinion by our expert, and that Daubert motion was denied. So this has been around a while, but the reason that we filed
Well,
the First
forgive me for
Amendment-
interrupting, Mr. Alderman, but at the beginning, I said what I thought I understood to be that issue about the fact that it's been around for a while. But I would like for you to let me know if I understand it in the same, I mean, like if we're speaking the same language about the import of that wage differential. So as I understood it, the way it originally bubbled up was that the experts, in order to calculate the benefits that these firefighters might have been entitled to, engaged in some exercise in which they figured out if they had been paid if they'd been compensated as full-time employees, these are the benefits they would have been entitled to, and that somehow that morphed into a straight up claim for there are wages these people were entitled to that they were not paid. And that's what I understood the purpose of the amendment to be, is to assert a wage claim that I did not understand to be there, as opposed to the potential wage being a framework for understanding how much benefit they might have been entitled to.
Sure. So it's always difficult and scary for me to tell you what you understood. But what I can tell you is what our expert, Mr. Lowell, put in his report was two things on this issue. And this is going back to his original report, his deposition, the Daubert motion. All of this was at issue in these two things. One was a wage differential claim for money damages in underpaid wages. The other was he did two calculations for the other benefits, non-wage benefits. And one set of calculations was based on this increased wage based on a full-time wage, which you're probably familiar with by now. The city has this list of wages for full-time and part-time employees at different positions. They didn't have a full-time wage for a firefighter because they treated them as part-time employees, although they worked more than 40 hours. So he couldn't look at the full-time wage. He had to calculate it.
Right.
And then, so like I said before, he's got one component of damages is you should have paid them the full-time wage. They were underpaid. I can't quote the number, but X million dollars in wages, plus all of these sick leave, holiday benefits they would have gotten would have been higher had they been paid at the higher wage. So both were involved. Both were at issue in the Daubert motion, and both were at issue in the motion limiting. So during those oral arguments, one of the things that it was actually your question to our side at the time was, did you plead this? And we had some general language that we thought was sufficient under pleading standards to implicate that. But we thought, you've raised the question, this argument keeps coming up. It would come up twice at that point. Let's just file an amendment and make it crystal clear, as we said, crystal clear that we have this claim so that we don't lose this claim on a technicality. So that's our view of how things happen and what we were trying to accomplish by the First Amendment. It's not, from our perspective, anything new. It's not anything the defendants are surprised by. It's something their expert has encountered and dealt with, something they filed several motions on. So Second Amendment, I get it, very new, transforms the case. First Amendment, just really making it clear what we've been arguing about for the entirety of the litigation. And I think the standards, legal standards matter here. context too. At least in my view, there were two prior motions seeking to exclude this evidence. And that's what we talked about at the pretrial conference, was a motion in limine directly seeking to exclude this, which was denied. But both the Dauber motion and the motion in limine had more generous standards for the defendant than this motion for judgment of the pleadings. So if we can surpass those hurdles, which we already have, then we can certainly surpass the motion for judgment of the pleadings. Then the third point is really, it's the substantive issue. The city says that there is no contractual basis. In our briefing, we pointed to these wage clauses, which give the city discretion to determine what the wages are. But what we pointed to, and which Mr. Lell summarized, are all these cases in Georgia that say, in a contract, if one party gives the other discretion to set a term, like a price, or in this case, a wage term, that party has to exercise good faith. And that's all we're saying through this claim. That's all we'd like to do at trial, is have the opportunity under the policy manual contract to say they had to exercise good faith in setting wages. And to the extent that they employed workers more than 40 hours a week, but failed to treat them as full-time workers and established a full-time rate as they did for every other position, that was not good faith. And that's what we'd like to prove at trial.
Okay. So going back again to sort of, I think it helps me to shoehorn, right? The remedy, as I understood this all along, where it became an amendment, where the plaintiffs decided that they needed to amend the complaint to make clear that they were asserting this, was sort of when it morphed from a structural method that the expert had created in order to value the benefits that are clearly at issue in this case, right? No question that the value of the benefits they might have gotten had they been properly or whatever characterized as full-time employees, clearly at issue. And I think I understood way back when we were looking at Daubert that the experts, because there was no structure for a full-time employee, they sort of had to invent it, right? And that was one of the issues that the city took with those calculations. I agree with you that my ruling was that's the scope of that. We might massage a little bit when we get to trial, but that's all fair game in terms of the experts trying to arrive at a value. But what the amendment implicates is an item of damages seeking additional wages that they were not paid and should have been paid. That's what I understand that amendment to be seeking. And what I'm trying to understand from the plaintiffs is under what theory, because the city wants to say you're trying to get it under the breach of contract and there's no contractual right to that in the policy manual. And then I hear you saying good faith, which I guess would sort of go to that second cause of action for breach of good faith and fair dealing. But talk to me about, where is this a remedy for an alleged breach of contract? Is it a remedy for the breach of good faith and fair dealing? Is it a quantum merit theory? That's what I'm not understanding. And even when I look at the amendment, it doesn't clearly, it talks a lot about the remedy, the damage, but it doesn't necessarily, at least as I understand it, say, as a result of the city's they breached their contract to pay us these wages, or they acted in bad faith. That's the part I'm missing.
Sure. It is a breach of contract claim, and it is based on the policy manual. There is not a contractual term there's not a contractual term in the policy manual that says firefighters should have been paid X dollars per hour. So our claim isn't, the contract says you should have paid X dollars per hour, but you paid Y dollars, so we're entitled to the difference. Our claim is there is a contractual obligation to set wages, and it gives the city discretion. And because it does that, they have an obligation to act in good faith. So it is a breach of the implied covenant of good faith and fair dealing is a breach of contract claim. And so it's both of those. But it is a contract claim falling under the policy manual.
Okay. Thank you. Anything else, Mr. Alderman?
No.
Okay. Mr. Lael, rebuttal by the city.
Well, Your Honor, I would simply highlight a couple of things that the court pointed out that Mr. Lowell, the plaintiff's expert, used a structural method, and that is absolutely right. When he came up with this notion, he didn't say the policy manual provides blah, blah, blah. That's what he did for all the other calculations of benefits. He said for vacation, it's you accrue it at this amount, and then when you have this many years of service, you accrue at a higher amount. He was relying on the policy manual provisions for all those damages calculations. But for this one, he said, well, I didn't really have anything to work with. So I took the median of the salary survey data, which again, we contend he miscomputed. But in any event, he said, I took the median. Well, why'd you take the median? Well, I didn't really have anything else to go on. So this is definitely an actuarial, well, I would say it's a structural method, which our expert says is not really actuarial because there's no real basis for it. It is not something based on policy manual language. And that is why we emphasize so much here in this motion that there's just not a contractual provision or a policy manual provision that would provide the foundation for a contractual claim or a claim of good faith and fair dealing, because it's just not there. Again, in the way that some of these other cases, they put in their brief deal with a very specific scheme to get around a contractual obligation. They just haven't alleged that here. And I think given the structural method, not the policy manual basis for how this came up originally, and that they haven't been able to identify a similar sort of scheme on the part of the city, means that this motion should also be granted.
Okay. Thank you all very much. I'm not going to rule today. What I am going to do is stew on this for a bit and then try to get everybody an answer as quickly as possible so y'all can figure out what we're doing. I will say one question I did have, and we can stay on the record if y'all want. We can go off the record because most of my questions now are really related to logistics, depending on the outcome of these motions. So if I deny the motion to dismiss, then on the second amendment to the complaint, then I think everybody agrees that we would have to spend some time figuring out who is in the class, who's not in the class, to make it official. But it feels to me like the parties probably have some idea of who is actually implicated and how complicated that might be to put our arms around. I say that because before I ask for an answer to that question, I'm curious, am I correct in my assumption that regardless of which way I rule, that if I dismiss it, the plaintiffs are going to appeal, and if I deny the dismissal, the city's going to ask for a certificate? Is that an accurate assumption?
We are, Your Honor.
Can I ask
And
a
that's
question real
accurate
quick?
for the
I'm
city
sorry
as
to
well.
interrupt.
Yes, Ms. Court Reporter, Madam Court Reporter.
Ma'am, I apologize. Did you want to go off the record? Because I
Well,
didn't
I
hear
was-
anybody agree.
I didn't.
So
I'm okay with it, but I wanted to leave it open to the attorneys since they're the ones that are paying for your very valuable time. So
I'd prefer just to keep it on the record.
that's totally fine. And that's why I sort of kept going when nobody jumped and said, yeah, sure, that's fine.
okay,
Thank
got it.
you.
So yes, ma'am, we are still on the record.
And we have been. So okay, got it.
Okay. And Mr. Lael, I think I understood you to say that that is correct for the city, that y'all will likely request a certificate.
That's right.
Okay. That's what I thought. So
Your Honor, if I could, in terms of, we do believe there needs to be a new kind of class certification and a new class definition, which I think also underscores the fact that there were two different claims, but since the class definition doesn't apply. But we think, I think 3 months, because it's not going to be super complicated. It opens it up, obviously, back up, and there needs to be a new damages calculation and all that. But I think we could get all of that done in a 3-month period of time. And then, of course, as we've talked about before, once your class certification order comes out one way or the other, there is an automatic appeal at that point.
And
And then
thank you.
everything.
Right.
goes,
That's
right?
where I was getting to, is that I had a vague recollection that we had discussed that issue, that if we do it all at the same time, right, then it goes up.
It all goes up. So if
It all
Mr.
goes up
Lale,
automatically.
so Mr. Lale and the city had requested, I believe, a certificate from the original summary judgment order.
Right.
Because you didn't grant summary judgment on all of the grounds they had requested.
Right.
And then that request was denied. But
Right.
whatever they have,
Whatever
yeah,
issues are
preserved,
available at the
whatever's
stake,
been
it goes
preserved,
up. Okay.
all goes up. And so then it could come back down and be a clean case where we know exactly what we're trying, what we're not trying, all of it. It's a much more cleaner case than getting the verdict and then going up and then having something happen where it's like, okay, now we got to come back down and redo something. So just in terms of judicial efficiency for what it's worth.
Thank you, Ms. Jordan. Mr. Lale, you agree with that assessment, that that's likely the route that the case will take regardless of the outcome of the, I guess if I deny the motion to dismiss, then, or excuse me, if I grant the motion to dismiss, we'll get there a lot faster. But what are your thoughts on that, Mr. Lale?
Well, Your Honor, I will just speak on behalf of the city. We have litigated this case for 6 years under a class definition, and it's been a pretty intense case. And so I guess what Ms. Jordan is suggesting is that we just keep going forward and litigating more. And then at some point, then we appeal. I think in light of the city, I have to take a stance, and I haven't discussed this particularly with the city attorney, but I think in the city's interest, it would make sense to appeal now. And if the Court of Appeals says, well, yeah, we think this is a permissible amendment, we think the longer statute of limitations applies, and we come back down and we kind of ramp back up and do what we have to do with any claim that remains. But if we have the appeal now on all the issues that have been preserved, it seems to me that would be the more efficient use of the parties' resources and a more efficient use of the court's resources as well. Because having overseen this case for maybe 3 or 4 of the 6 years total, that these issues are going to be tested on both sides as to, well, is this the proper class definition? Is this all of this has been tested pretty well by both parties. Now, of course, all of this is within the court's discretion. So you can certainly say, no, I'm going to side with Ms. Jordan on this one. But again, I just wanted to raise the city's interest here that, we've had to defend this case for a long time. And, I think a quicker appeal, to the extent we're going to be appealing anyway, makes more sense to do now than later.
Okay. Well, I will tell y'all that I got really, really excited about 2 weeks ago when I saw on the news that the city of Roswell is making some changes to its firefighter compensation plan. And I thought, maybe that means they settled the case. No such luck. The only other thing I will point out is when you were interacting with this case in Odyssey, you might have noticed that there are now document numbers that are associated with the individual docket entries. And so Judge McBurney and I spent basically the better part of the pandemic convincing Tyler Technologies that they needed to do that for us. So it should make your appeal and citation process a lot easier.
Thank you for that.
It makes my life it is a little sad how happy I was the first time I drafted an order that just had at the end of the sentence, document 1, instead of having to say plaintiff's complaint for whatever, blah, blah, blah. So, okay. So my goal is to advise you guys what my ruling is going to be by email. And I'm probably going to request proposed orders, although I expect that I will edit them heavily because I think there are issues that I think are more dispositive or more significant to me than others. but I probably will ask you guys to do a little bit of the heavy, the rowing part of that, the heavy lift, so that we can move it forward more quickly. My goal is to let you know by the end of next week what my ruling is going to be. Hopefully it will be sooner, but the end of next week at the latest, what my ruling is going to be on both the motion for judgment on the pleadings and the motion to dismiss as it relates to the First Amendment and the Second Amendment. And then depending on what the outcome of that ruling is, I think we'll need to decide. I expect, as I said, if I grant the motions, I expect that the plaintiffs will appeal. Hang on. It's an incomplete motion to dismiss, so it would still be interlocutory, right? You would still need a certificate or no? No, you just take it up with, you can take it up directly, even though it's not the entire case.
I feel confident that's true. If you,
Oh, I'm not questioning you. I'm asking for you to educate me. I did not mean to imply that I knew something you didn't, Mr. Alderman.
I didn't take it that way. I think if you grant summary judgment on even a partial claim, I think against us, then I think we have the ability to take it up directly.
Right.
Okay.
If you deny, I think if you deny the motion, then it becomes interlocutory. I think if you grant it, it goes up. If you
Right.
deny
That's
it-
what I thought, is that if I grant it, it goes up immediately. If I deny, it's going to need interlocutory relief and I'll expect an immediate certificate request. The only reason I even questioned it momentarily is because it's an incomplete grant and is not dispositive of the entire case, which sometimes implicates interlocutory process instead of direct. So I was just asking for that clarification. Okay. Do y'all need anything else from me today?
No, thank you for your time.
Okay, excellent. Well, thank you all for your preparation and for educating me, and I will get you a ruling as quickly as I can.